I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are walking into number 136 on our compilation list. We will be in 3 different courtrooms on today. Before I give you the rundown of those courtrooms, don't forget to like, comment, share, and subscribe. If there's some old proceedings or particular sovereign citizens that you want us to do a compilation on, please let us know. We will go in the archives and see if we have any of those videos, and we will make sure we add them to future compilations for you. Also, chapters will be added for your convenience. A little bit of commentary also will be added from some of these previous proceedings that we are sharing on today. And with that being said, let me give you the rundown of the courtrooms that we will be in. First, we will be in the courtroom out of Dane County, Wisconsin. Second, we will be in the courtroom of Judge Sam Meyer out of the state of Washington. And last but not least, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. As always, guys, I hope you are having a great holiday weekend, and I pray that you have a great new year as well. And it's about that time, guys, that we walk into 136.
I have to assistant counsel.
I'm sorry, who do we have here? This is Mr. Griffin.
Anthony. I'm not administrator. I asked for assistant counsel, not counsel.
That's fine. We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25 CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin
appearing expressly.
Wait, you need to stop talking. Is Mr. Griffin appearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin that is charged? Stop a second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25 CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later.
I will hearing. As I've been held for 72 hours without seeing the judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this. Okay. I'm going to find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your objection is noted.
I'm a more. You have.
If you keep talking over me, we're going to cancel this.
Talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
You're not allowed. No, you're not allowed to talk about
an attorney. I am not.
Okay, let's hold him in custody or canceling this hearing. You're going to have to.
That's okay.
You're not willing to cooperate. Make a record
show that you're violating my rights. Let the
record note that he refused to cooperate so that an initial hearing could be conducted. That's 25 CF 939 appearances.
88 Sister Marco for the state.
Understand where the Vice Defendant's office refers to Mr. Griffin has indicated that he wants to take care of his own case.
Right. Is that right, Mr. Griffin?
No, I'm not Mr. Griffin. I'm Anthony of the Griffin. I have the power of attorney for him. I do have a question for the court. Will I be allowed to speak freely, or will my civil rights be again granted over?
Oh, you get to make a statement on bail, but we're going to do this in an orderly fashion. But you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself.
It's not about me identifying myself and be very very about all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am on board. So a lot of things on here are totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. As for the record, all savings for the record comes now the living man and the other Griffin family. Ensuring there is appropriate persona status appearing expressly to continue the record arrest accordingly. I'm not to be mistaken with the all caps estate, as I am the occupant of the executive office and also the sole beneficiary of the state. I filed my power of attorney with the court and I'm ready to proceed. Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed court was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or people taken until I have a court order from the judge. I do not argue with any of the facts in this charge against me. This is not me taking a plea. This is accepted for value and returned for value. All the charges continues in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's
I've never
okay.
heard that ever.
That also means that this
You
is not
can file your written motions,
not a
Mr. Griffin.
competent court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the filming records match this particular individual. I'll find probable cause.
Man can be awarded over his own case.
And where would you like us to send mail, sir?
You already have mail. I told you on file. It's P.O. Box, the Forest, Wisconsin,
Okay,
53532.
thank you.
And I have a right to be
What's
all recognizance.
the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the Wisconsin statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled. I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure not that when somebody has a court date that they have to be served the court date so they know that it's there. Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that. And I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was, I don't know, hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be
She's
doing any of that,
as the
Mr.
state,
Griffin.
and she is not the state. I know her not. I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're gonna have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body-only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object, and it's clear that
And that's
these
fine.
rights have been violated, and you're still moving forward. This is called an obstruction of justice.
Don't,
Let the
even if
record
your
show
rights have
that.
been
Know
violated.
everything that I've said.
It's all being recorded, Mr. Griffin. You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
Well, I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, that means
You're
you don't
gonna
have
have to,
authority over
you're gonna
me.
have to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
Are you
statute.
responsible for
And because I haven't heard a response, I don't believe we have a waiver of time limit to set a time for
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned. Mr.
Okay,
Griffin.
since you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. Bad for the team, never us.
And then Mr. Giorno,
Thank you.
come on up. You're here on a couple of things, no valid operator license, but with valid ID, and then a seatbelt ticket. So I guess we'll start with, those are 2 things. And again, a valid ID, that's the same, you're free to go if you wish. Yeah, you can go ahead and just go line up at the window. You can stay if you want to, no one ever does when I make that comment, make that offer, but.
Thank you.
Mr. Giorno, like, again, the license issue, that's a pretty cut and dried thing. You have a license now, it looks like you do. Looks like you got the license like 2 days later. And then, so how did you want to, so again, how did you want to proceed on the seatbelt ticket?
Well, I'd like to contest the hearing, Your Honor.
So you're contesting on this speeding ticket, but then mitigating on the valid.
Seatbelt issue.
Seatbelt ticket, I'm sorry, you're right. You're contesting the seatbelt ticket, but you're mitigating then the license issue?
I'm contesting it, Your Honor.
Okay, okay. Could you raise your right hand, please?
Yes,
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Seatbelt ticket first. What, did you get a chance to review your police report?
I did.
Okay. Go ahead.
And I set forth a motion for discovery, and I had a couple of questions, and
And you submitted, give me just a moment. So you submitted a discovery request?
I did.
You did.
Yes,
Did you ever get anything?
I did. All I got was a printed tick the box return. I had 2 questions that weren't answered.
Okay, so Give me just a minute. Okay, so I hereby set forth a request for discovery concerning the above case.
Yes,
And then I also request any evidence that you're subject to the codes concerning this case. And you request any evidence that you're in any type of contract concerning this case.
yes.
Okay, so the discovery typically is a police report, an affidavit or some sort that says what happened out there. Did you get that?
I got a tick the box.
Right, that's right. So that's the evidence there. And then on your the codes, it should say on your infraction where you were served with that. It has the right there. You go look right next to there. They'll have the codes there.
Your Honor, I was asking for some evidence that I subject to these codes. I got nothing from the prosecutor's office. I didn't get a reply to either.
Well, they don't have anything to that about that, first of all. And secondly, I request evidence that you're in any type of contract concerning this case.
Yes.
There isn't any.
Right. So
that doesn't have anything, whether you're in a contract or not. I don't know why people make this argument to me. I really don't.
Okay.
But there's rules of the road. You need to comply with them. There's, you go on the freeway, you see all the people on I-5. None of those people have contracts to drive on the highway, but they're required to follow the rules of the road, including have a license and don't drive under the influence of alcohol, maintain the speed limit and all that sort of stuff. There is no contract of any sort. That's just the rules you got to follow. And that's been litigated quite, for a long period of time. And the absence of any sort of written contract or oral contract with anybody, I will tell you that that's not a winning argument. It's just not.
Okay, but returning to being subject to the codes, there was also no response from the prosecutor's office as far as being subject to these codes.
Well, again, anybody who drives on the road are subject to the rules of the road. I mean, they just are. You don't have and again, taking that away from the traffic, you're not allowed to rob a bank either. You're not allowed to assault people, but there's no, you just live under those codes. You don't have, no one ever came to you and said, hey, you're subject to the code that says you can't assault people. The same is true with driving. You have to be licensed. In order to be licensed, you have to take a test. You have to both driving and written. And then that when you choose to get on the road, you're subject to those. You're just subject to all the laws in the state, whether or not it's traffic or not.
I understand but there is no injured third party. You abide by the rules. No one gets injured.
That's and again, I've heard that too, and I have zero idea where that comes from, because that's just not true. I mean, like for example, then people could drive drunk as long as they didn't hit anybody, they're fine. But that's certainly not the case.
Well, that would be,
that
would be reckless driving.
And you can commit crimes without hurting individuals. I mean, just because no one got hurt, no harm, no foul might work in the NBA, but that's not in terms of the rules of the road. You have to comply with them. So again, the issue, and again, I will tell you what the issue is they're very narrow, right? What you're charged with is not having a license, but without identification, or not having license, but with identification. And so that's it. I just make a determination. The police officer said in his report, you didn't have a license with you. And then it looks to me like you got one shortly thereafter. And that's, did you have a license when you were driving or not? That's the only inquiry. The second inquiry is, were you wearing your seatbelt or not? That's all there is to it. And so that's what I'm asked to decide. So I can swear you in and I'll hear from you. And then following that, I'll read the report and then I'll make a determination on those two issues, whether A, you were wearing a seatbelt, and 2, you were operating while you didn't have, without a valid license at the time. That's it. And you could mitigate, you can ask, you could admit that, and that, well, the license ticket, that's an expensive ticket. And so again, if you want to think about what you want to do, I think Mr. McIntyre, I think is probably taking a little bit more time than we thought. So I can take care of him. If you want to think about what I'm saying, maybe this is coming as news to you. I'll hear from Mr. McIntyre and then I'll come back and hear from you. So Mr. Giorno, where are we at?
This is
I've
Ms.
got one last thing I
Johnson.
want to say about the prosecutor's responsibilities. They're required to give you everything they have regarding this case. And this is all there is, just that police report and the citation. So there's no, this isn't a speeding ticket. There's no speed measuring device. There's no pictures or anything like that or video. It's just the officer's report saying that you didn't have your license and that you didn't have a seatbelt. So what do you want to do here today?
Well, I had a seatbelt on and I would like
Okay.
to.
So if you want to contest it, then let me, I can't even remember now. Did I swear you in?
Yes, sir.
Okay, so talk to me about the seatbelt.
Well, the officer's report is fabricated hearsay. I say it's inadmissible hearsay, and I motion to strike because.
So
this
hang
is
on just a minute,
incorrect.
let me get the report up. How is it hearsay?
He says I admitted to it. I did not, of course not. And I would like to see the video. I'd like to cross-examine.
There is no video.
Okay.
And if you want to, you need to make a request to have the officer present in order to do that. If you want it, and then in the absence of having the officer present, I can decide it from the court rules are clear on that. I can rely on the report. I want to set it over for a period of time to most people ask for the officer to show up, hoping they won't, if you want my frank opinion. But if you want, I'll give you the benefit of setting this over to have so the trooper can appear if you wish to do that.
Well, I object to that, Your Honor, because I showed up today and
Right.
it seems you.
But you need to, again, this is another example of you need to follow the rules. In order to have the trip, you have to provide a request for that in advance of the hearing. We never got the request.
Your Honor, I understand that it's the burden of proof is on the plaintiff.
True.
So the officer's not here.
That's
There's
true.
a failure to appear. So I can't cross-examine the
Yeah.
officer.
But I
And
don't
he
think,
did say that it was videoed.
well, they might not, they probably, again, on takes like this, we wouldn't have preserved that and sent it to the prosecutor's office. You didn't make the request to State Patrol to get that. You made a request to the prosecutor's office, what they had for the case.
Well, it's a little hard to discuss things with State Patrol.
What's that?
It's a little difficult to discuss issues with State Patrol when they are in a certain mode.
Okay,
So,
what do you want to do here? Again, I'm still not too clear.
Well-
If you want to contest the seatbelt, we can do that. And then tell me what happened out there. Were you wearing your seatbelt? And if not, why not? And tell me what the misunderstanding with the officer is. Well, go ahead.
well, the officer could not have seen what I was doing either way because he did a 180-degree wheel spin in the middle of Yelm Highway, where I've lived for 35 years, to pursue me. I, as far as I know, had a valid driver's license and have always had a valid driver's license. So I contest that I don't have any evidence from the prosecutor's office. I don't have any witness to cross-examine.
You do have evidence from the prosecutor's office. You have that report.
This is a print, Your Honor.
I know what it is. I'm looking at the same thing.
I have one, the original.
At the bottom of it, you can say it was certified under penalty of perjury. And then there's the officer's signature on there.
Well,
Give me just a minute. Give me just a minute here.
Okay.
Yeah, the court rule says, with regard to the officer not being here, upon written demand of the defendant, at least 14 days before a contested hearing filed with the court and served in the office of the prosecuting attorney assigned to the court in which the infraction is filed, the prosecuting attorney shall at least 7 days before the court hearing would provide you with a copy. That's not what I'm looking for. In a minute. Oh, yeah. On earlier in that same rule, a request that an officer appear at a contested hearing pursuant to this rule shall be filed in a separate pleading, and it may be directed. And then someplace else in this rule, it says, in the absence of that request, the judge, me, can rely on the police reports. And that is a police report. Yes, it's short, but that's what we have. And again, that's so. Do you have anything else? Because I'm ready to rule on these cases. Unless you, and again, I'll give you the opportunity to set this over and have the trooper present if you wish. You're here now. I don't have to, but I will give you that accommodation if you wish to take advantage of it.
Decisions. It's decision time, Mr. Giorno. What are we going to do?
So there's no prosecutor present, there's no witness present. I'm not having, doesn't seem I'm allowed to have a fair trial. I believe, if I'm not mistaken, it's an adversarial court system.
Right.
We have two parties. There is no injured third party. I still don't get an opportunity to cross-examine, and they have failed by default to appear. So I don't see why this should continue on.
So they don't, the prosecutor doesn't need to. They're not required to. And the fact that they don't on these infractions, again, they rely on the report. And so, and that's just what they do. And sometimes they do that to their peril. You don't know how I'm gonna rule on these cases. And sometimes these reports are incomplete, or I don't know, you were here at 1:30, they didn't even file one. So the case was dismissed and the woman who was there just left. And that happens sometimes too. And so the rules allow for this sort of procedure. And like I say, I'm giving you the opportunity to have that trooper present if you want to take it. And so you've complained about, he's not here. And I've tried to explain to you that it's not, you're certain things you have to do to get him or her here. And you didn't do them, but I'm giving you the opportunity to set this over so you can speak with them if you wish. And it's entirely up to you.
Well, I'm here for the hearing. I mean,
Right.
It's going to be a fair trial. I mean, you seem to be, arguing for the plaintiff, whereas
I'm not, I don't mean to be doing that. I'm just trying to explain to you what the rules are. And in certain instances like these, they don't have to do things. And so I'm not saying about the sufficiency of the evidence. I'm not saying, well, you should be convicted or be found committed for this reason or for that reason. I'm not saying any of that. I'm just saying these are the rules for this sorts of procedure. And if you perceive that as me being on the side of big arguing against you, I'm sorry about that, but that's not what I'm trying to do.
Well, this print that the officer gave me, I did not and was not able to see who was in his vehicle.
Okay.
So I have no idea who printed that up. I have no idea. There is no personal signature on anything. And yet again, I'm here and showed up and they don't have a case. They're not here.
Well,
I'm a little bit perplexed by that.
so here's what I'm prepared to do here today. With regard, you have two infractions here, and with regard to you're correct. You've shown up. I've sworn you in. I've listened to you testify. With regard to the seatbelt ticket, I'll give you the benefit of the doubt. It will be a finding of not committed on the seatbelt ticket. However, with regard to the license, based on the report of the The police report combined with the fact that on your ADR, which I'm allowed to look at, it looks like you were issued a license 2 days after this. It will be a finding of committed with driving without the license.
Your Honor, I forgot to bring my old license in. You can't read the date on it. I mean, it's just,
Okay, so again,
you know, but it sounds like an entrapment. It's not like the Department of Licensing sends you a notice because what license went in the laundry or whatever, you can't read it. And suddenly I'm just driving like normal, like, and it's like, oh, that's crazy. I couldn't even read it. And I'll bring it in.
I'm going to go back to, and I'm going to say this one last thing, and and then I told you how I'm going to rule on these infractions, but I will respond to that.
Yeah.
In this manner, and that is, you know, it's again, when you get on the road, it's your responsibility to comply with the rules of the road. It just is. And part of that is it's your responsibility to make sure you're appropriately licensed. And I don't, again, I'm not seeing it. You're right. You didn't see that. I don't know what it looked like when it came out of the laundry, but that's going to be my ruling on this case. And so they'll be not committed on the seatbelt, and that'll be dismissed. It will be committed on the no valid operator license, and the fine is since you got a license shortly thereafter, I will reduce the fine. I'll chop the fine in half.
But I got
The fine,
discovery.
The fine will be, and again, hang on just a second. The fine will be $280. And again, I tried to explain to you, that is the discovery, that police report, that's what it is.
But discovery did not say that I am subject to these codes.
Well, when you, again, I tried to explain that to you too. When you choose to get on the road, you know, you're subject to the rules of the road. You need to follow.
But I object. This is not fair.
You can object and you can appeal if you wish also.
I will.
Okay.
I will. This is not fair.
You can go, you can give him a piece of paper. You can come up this and you can take this to the window and you set up payment arrangements, file your appeal or whatever you wish to do. That's fine. You're certainly free to do that.
You're acting as a prosecutor, giving me a bill. I disagree. This is not fair. This is not a fair trial. They didn't show up. So the onus and burden of proof is not on me. I'm not subject to these codes according to the prosecutor's office. So I'm not subject to a fine until we have a fair trial.
Okay.
Fair and impartial.
Okay, I've told you what I've ruled. I've tried to explain to you the rules of infraction hearings. They don't necessarily need to. Sometimes they choose to, sometimes they don't. They don't have to. They filed the police report. I can rely on that. The court rules allow that. I know you disagree with that, and that's
the officer doesn't even have the decency to sign his own name.
And you can come and take this and you can take that to the window and set up payment arrangements. Or if you want to refuse to pay it, it'll be an unpaid infraction. And I'm not, you know, I'm telling you what I've done here today, and that's going to be the hearing will be concluded.
You didn't offer me another option that you stated at the opening of this hearing. You didn't offer me a deferral.
I did offer you a deferral. You told me you were wanted to contest it. I mean, I clearly offered you a deferral. I thought I said that at the beginning. I went through all three options. And
at the beginning when everyone was present.
Yeah. And I told everybody what their options are. And then when they come to the table, they tell me what they want to do.
Yes. Well, I was pursuing a line of contesting this.
Right. And that's what you did. And then I made my ruling. And I ruled against you, which is what happened here today. So you can come and get that or refuse to take it, whatever you wish to do, but this hearing will be concluded, and that'll be it for this hearing.
Well, guys, we've come to the end of this proceeding. And as we can see, Mr. Joyner wasn't happy with Judge Meyer's decision. He feels like the whole proceeding has been rigged. Nobody showed up. He feels like Judge Myers is working on the prosecutor's behalf and, handing out the fines, like he's working for the prosecutor's office and so on and so forth. But the bottom line is Judge Myers explained to him the best he could, broke it down in very simple terms. And, either Mr. Joyner don't want to understand, doesn't understand, or he's pretending not to understand. Whatever the case is, Judge Myers has made his ruling. Mr. Joyner said he's going to appeal. If he does, we'll try to keep up with it. But as always, I appreciate you guys for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, share, subscribe, and comment. It is much appreciated. And listen, we're getting ready to get out of here, guys. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Talk to you guys soon, and God bless.
All right, DeMarcus Cantrell Brown.
We are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I have not right now. I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right? Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay.
Okay. I got you. So,
all right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have?
Wait. You see this book right here? This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not
books.
that way.
Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So it's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay / Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them. So first of all, right here. The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m. So DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
If the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on. Let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm not. I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay. Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off mute.
What's going on is he's a member of a foreign state corporation basically doing business in Georgia. So
okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying, man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on.
We understand the rules of the court. We understand the rules of the court. I got you.
Okay. Are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to realize
then as he can represent himself.
You need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia. But he cannot have you represent him or purport to represent him. Okay, that's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
That would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the bench. Violation 28 U.S.C. 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
I object.
All right, sir. Thank you. You'll get notice in the mail. If anything changes about your changes about your address, then you can go ahead and let us know by coming into.
I demand an evidence hearing.
You will have that at the time of the trial,
evidence hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
dishonorable. I got your oath, Tammi Long. Hey.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrows.
I'm not threatening you. Say one more word and that's 30 days. 30 days.